Welcome to Legal Masterminds at Law Leaders. I'm your host, Dustin Ruge, and joining me today to talk about updates to Arizona's alternative business structure and referral fee reforms is Lynda Shely of the Shely Law Firm. Lynda, thank you for joining us.
Thanks for having me, Dustin.
Absolutely. So a little bit about Lynda, for those who might not know Lynda already. Lynda is a renowned ethics attorney based in Scottsdale, Arizona. Amongst many of her awards and accomplishments includes advising over 2,000 law firms, is the immediate past chair of the ABA Standing Committee on Ethics and Professional Responsibility, and past president of the National Association of Professional Responsibility Lawyers. Lynda currently serves on the Arizona Supreme Court's ABS Committee and ABA Standing Committee of Professional Regulation. She also assists the Arizona Supreme Court's task force on the delivery of legal services and the drafting of many of the recent Arizona legal rules changes that we will be discussing today. So it's been nearly 3 years, Lynda, since we last talked, and since Arizona became the first state to really change the legal model rules, allowing with certain restrictions for the referral fee or for referral fees for non-attorneys and the creation of alternative business systems by eliminating Section 5.4, which now allows for non-attorney ownerships of law firms. Lynda, you and I first spoke about these changes over 3 years ago, in fact, right before they took place. And for those who want to watch that, I will have a link to the recording of that below. But many attorneys have been asking now that we're almost 3 years in, where are we and what have we learned and really where are things heading at this point? So that's really what I wanted to kind of focus in on today with you, Lynda. So to begin with, I wanted to do a quick rundown for everybody of where we stand in Arizona with the ABS reforms. There are currently now, at the time of filming, 65 ABSs registered in the state of Arizona. And the breakdowns are by the following practice areas. Personal injury and mass torts, we have 26 firms. Business law, 10. Estate planning, 10. Civil litigation, 6. Immigration, 5. Family law, 2. Intellectual property, 2. Bankruptcy, 1. And then 7 other various sorts. So I guess, Lynda, when you look at that list now and think about the other nations and other jurisdictions that have similar ABS models, how does that break down by practice area and total number of firms that have become ABSs meet with not only the expectations maybe you and others had when we began this process, but how it kind of compares just with everybody else at this point?
Well, interesting that you should ask how it compares because in the United States, only Arizona and Utah are basically testing this out. Arizona completely changed their rules. And just to reassure everybody, no, I've heard nothing about changing the rules back. This was a permanent rule change. Utah, on the other hand, has a sandbox or pilot project going. And by the way, if anybody's good at math, those numbers should not add up to 65 because some of the firms have more than one practice area, obviously. So that's why the numbers are not even. I can say, and speaking in my own personal capacity, not on behalf of the ABS Committee of the Arizona Supreme Court, but I think we're excited that we have 65. There are 35 applications pending as of the date of this recording, so still lots of interest in it. And just comparing us to Utah, because the programs are very different. The ABS law firm licensing program, because in Arizona, it's a law firm and it is licensed by the Arizona Supreme Court. It requires disclosing a whole lot of information up front. And I would say that of the firms that we have licensed so far, the practice areas are very different than those that Utah is experiencing. They're not seeing as many personal injury mass tort firms, I think. They're seeing more in the way of immigration, bankruptcy, veterans' rights, estate planning, things like that. And
Right.
the Utah program only has 49 participants in their pilot project, and they've actually stopped taking applications for right now. They're kind of gathering data to see whether this has actually addressed the access to justice issue and that was the reason that Utah adopted their program.
Very interesting. Good. Well, I remember when this whole process started, there were a few dissenters, and I know a few of them probably rattled you and everybody else about these changes. But, some of those dissenters had previously predicted a lot of doom and gloom around this with the passage of ABS referral fee reforms over 3 years ago. And so far, has there been any credence to their fears and their concerns at this point?
Well, the detailed answer, Dustin, is no. Um, seriously, I appreciate, any significant change, and eliminating the rule about non-lawyer ownership in Arizona is a huge change. That concerned everybody, because fears that non-lawyers are going to come in, they're going to control what the lawyers are going to doing, they're going to control how many depositions lawyers can take and all of that. Very valid concerns, because we pride ourselves as a profession in putting the client's interest first. Fortunately, when we drafted these rules in Arizona, I think we put safeguards in place to make sure that non-lawyers who have any ownership interest or control in the law firm cannot control what the lawyer's deciding in the way of legal services. So, anecdotally, no, we've not seen a problem. I will say that publicly, I believe we're aware of 2 bar charges pending against 65, 2 against 2 law firms are pending right now that I'm aware of. And with 65 law firms, and anecdotally understanding that they represent thousands of clients, that's a pretty low statistic. So, so far we're seeing, knock on wood, that the safeguards that are in the regulations seem to be working.
Good, excellent. And I think that's probably a good segue to the second piece, which is people, I think, are still trying to and struggling to understand what is an ABS and what are the key components of that as an Arizona law firm. I know we're going to link to that below in our previous discussion, but maybe you could give a quick overview again as to what those key components are, so people really understand what this is and is not.
Right. Well, I have a personal ask of the audience. Every time you say the letters ABS, would you please put the words law firm after it? Because I think that's what confuses people. ABS, alternative business structure, confuses folks, but it's been around for years in the UK and Australia. In Arizona, it is a law firm. That is it. Plain and simple. It's a law firm. It happens to be licensed to have non-lawyer owners. It does not have non-lawyers practicing law. Non-lawyers stay in their lane, whether they're firm administrators, financial people, investors, technologists, whatever, and then the lawyers practice law. So an ABS law firm in Arizona, in order to apply, you have to have at least one compliance lawyer, and that compliance lawyer needs to be a fairly seasoned person. You cannot just hire somebody straight out of law school. They have to have some experience in management and supervision, whether it's in a smaller firm or a legal department at an entity. So you have to have an Arizona compliance lawyer, and then you have to have at least some non-lawyer ownership or decision making. So somebody who is going to be either investing in the firm, or in the case of several of the firms, they've had a firm administrator or a CIO or a CFO that they actually want to make as a partner in the firm. And you have to disclose a lot of background information. Lawyers who are watching this, you'll remember going through character and fitness and how painful that was in disclosing everything you did in your youth and any crimes or judgments. Well, that's what you have to disclose for everybody in this application. As well as, one other thing I'll mention, what the ABS committee of the Supreme Court really wants to see is, how are you going to achieve some of the regulatory objectives of supporting an independent legal society and supporting access to justice? And also, we want to know how you're going to manage the firm to comply with ethics rules. What are you going to do for confidentiality? What are you going to do for conflicts of interest? Which are questions we should be asking every law firm, right?
Right. Exactly. Exactly. And if somebody wants, we've got 65 ABSs in place, ABS law firms. Sorry, I got to get that correct
Good
now.
job.
And then 35 that are currently in process of review. But certainly there's been some that have not been approved, I assume, correct, going through this process. So when you look at the things that would keep somebody from getting approved as an ABS, what are those main things that people need to be worried about? And I think you just touched on one of them, but maybe we could just run through those requirements.
Sure. Um, Disbarred and suspended lawyers, either from Arizona or other states, don't apply. That's going to be a deal breaker. Felony convictions for fraud or misrepresentation, or judgments civil suits or misdemeanor charges of fraud, misrepresentation, breach of fiduciary duty. Those are all things that the committee is going to look at. The one that we've only had one that the committee voted to deny so far, because a lot of the screening happens with the Supreme Court staff who have to they hire an investigator and they have to do a background check on all these folks. And if they come up with things that are listed in the code of the Arizona Code of Judicial Administration sets forth the reasons why the committee can deny. If somebody's been terminated from their employment for misrepresentation or fraud, breach of fiduciary duty, judgments against somebody for, again, misrepresentation is really what we're looking for, but convictions for misappropriating money, things like that. There are a lot of things listed in the code that we ask about. And I would say probably the most common that I hear from folks will be, I have a judgment against me from a state attorney general because we violated some Consumer Protection Act or misrepresentation in a business dealing. Those things could be holdups to an application.
It sounds like there's quite a bit of investigation that goes on here. And when you look at going through all those processes, Lynda, right now, what would you say on average if somebody was to say from the time they apply to when they get certified, how long of a process are people realistically looking at here on average?
Well, assuming that you file a complete application, and I say that because it requires, we're looking at on average, each application that the committee has to review, averaging between 100 and 1,000 pages.
Wow.
Yes, that we have to read before each meeting. Thank you very much. Assuming you file a complete application with all the information that we require on the backgrounds of everybody who's going to be involved and on the business operations and the operating agreement and all of that, from the date you file to getting to the ABS committee's agenda, which is where the court staff then brings us the application package and says, okay, we've done the background checks on everybody. And either they recommend up or they recommend down. That was taking about 4 months, but now because we've had so many applications and we have renewal applications on top of that, so we're compounding the amount of investigation, it's taken about 6 to 8 months to get on an agenda.
Wow. Now, you mentioned renewal applications. How often do people have to renew as part of this process?
Right now, under the code, it says every year. Every year you have to file a renewal application with a filing fee and basically say, hey, has anything changed? You also, if you decide that you want to terminate the compliance lawyer or one of the authorized people, like Dustin, if you and I were partners in an ABS law firm and you decide, yeah, no, I don't want to be partners with Lynda anymore, and you withdraw and somebody else applies to be an authorized person, each of those has to be approved too. So the annual renewal may change. That's something that the ABS committee is looking at right now to say, if nothing's really changed and we're going to have to approve changes in management anyway, why not make this every couple of years?
Right. Understood. One of the other areas that I hear a lot of questions recently has been around how ABSs will interoperate with attorneys from other states. And that seems to be the biggest question I hear over and over again. So I want to walk through maybe a couple of those questions in particular to see how we would address those with individuals. So the first one would be, would an Arizona ABS be able to co-counsel and or receive referral fees with attorneys from other states? What are the rules around that?
Assuming that the lawyers in other states are in separate firms and they're just co-counseling with an Arizona ABS law firm, yes, that can happen. We had ethics opinions that address this from other jurisdictions, including one from the New York City bar from 2020 that specifically addressed Arizona ABSs and co-counseling with them. I am not aware of any state specifically saying, no, Arizona lawyers stay out. Our lawyers can't play with you. So there is an older Maryland ethics opinion, but I'm not sure that's still being used. So I've not heard of any state saying their lawyers can't co-counsel with Arizona lawyers.
Right. Okay. Another area is can lawyers that are admitted in other states be employed to work in in an Arizona ABS law firm? Are there any restrictions around that?
Detailed answer is no.
Okay.
So I'm
Assuming
keeping
they pass the test, right?
I'm keeping it simple here. Only Arizona lawyers can be employed in an Arizona ABS law firm, not because Arizona prohibits it, but because all the other states that license their lawyers will not let their lawyers work in an Arizona ABS if they're non-lawyer owners.
Got it. Okay, good. And another question is similar to the first one was, how are attorneys in other states allowed to work with an Arizona ABS? Can they take cases and share referral fees with an ABS in Arizona?
So not only can lawyers in other states co-counsel with Arizona ABS lawyers, but in addition to the ABS rules, okay, ABS law firm rules, we also in Arizona eliminated two ethics rules. Ethics Rule 5.4, which says that we couldn't share legal fees with non-lawyers, and Ethics Rule 7.2, which is the ABA model rule in most jurisdictions says can't give anything to anybody for recommending or referring stuff to you. Well, we eliminated both of those. So that means lawyers in other states also could co-counsel with an Arizona lawyer who's in a traditional law firm that's not an ABS. And that Arizona lawyer may be able to pay referral fees to a non-lawyer to get those cases, but the lawyer in the other state cannot pay a referral fee. So our lawyers can now pay referral fees to anybody, and that referral fee can be a percentage of the fees that the Arizona lawyer earns.
And that's a great question because that referral fee, I think it from an intrastate perspective, I think people understand what that means in Arizona. But if I'm understanding what you're saying correctly, if they got a referral from somebody out of state, they could pay that as a referral fee as well. Is that what I'm hearing?
An Arizona lawyer could.
Oh,
For everybody who's listening who's not an Arizona lawyer, you have to play by your rules.
right.
So if you co-counseled, for instance, with me, and since I don't do personal injury, this is a hypothetical. If you co-counseled with me and I had a referral from somebody out of state and I sign up the case, I can pay the referral fee to that person and then co-counsel with you. And we're just splitting legal fees between us the way lawyers traditionally do in a co-counsel relationship.
Interesting. Very interesting. Great. Another question that comes up a lot is around the requirements and restrictions for non-attorney investors in Arizona ABSs. When you look at them, there's a number of them now. And what I wanted to kind of understand was what are some of the general requirements and restrictions that they should be aware of from the non-attorney perspective, especially as it pertains to what is perceived as an authorized person and percentage of ownership as well.
So a non-lawyer may own 100% of an Arizona ABS law firm. They may own the entire amount as long as they employ a compliance lawyer to be the lawyer who's actually practicing law or make the Arizona lawyer a manager. And the requirements for the authorized person, meaning somebody who has either a 10% or greater economic interest in the applicant law firm, or they're going to be making decisions for the law firm. The authorized person can be any non-lawyer, any percentage ownership, and they will have to disclose their whole background. And what the ABS Code of Conduct requires, basically stay in your lane, okay? And it's more detailed than that. But it's basically you stay in your lane. Let the lawyer practice law. The lawyer makes decisions about who the clients are and how they're represented. And the financial person makes decisions about, okay, can we buy more furniture? Do we need more computers? Whatever. What are we going to have in the way of employees? Things like that. But the authorized persons who are non-lawyers also have to agree to be bound by the ethics rules, meaning authorized persons are bound by confidentiality, can't talk about clients, conflicts of interest apply, and all of that.
Okay. And let's take that a step further. Let's say you have passive investors that want to come in and say maybe they're less than 10%, like 9% or less, and they really don't want to operate as an authorized person per se, right? They just want to be an investor. Are they still bound by the same background checks and disclosures that other participants within the ABSs would be or not?
If they will have less than a 10% economic interest in the law firm and they are not being a decision maker, you're not bringing them in as your CFO or CIO, things like that, they're not subject to the same background check.
Okay. But are they still required to disclose who those individuals are?
No, they're
Oh,
not. They're not required to go. They're not listed as an authorized person, and the bunny ears mean that that's a defined term in the code, and those are the people who have to be disclosed. They're still bound, though, as anybody in a law firm. They're still bound to the confidentiality, conflict issues, and all of that.
understood. Okay, great. In looking at a number of the ABSs that are in place today, it looks like there's a number of them that are still kind of in the planning stage, right? And I guess what we're trying to understand is, how do these organizations then manage taking on new investors and owners over time after the ABS is formed? How would that mechanism look, and how would that take place within the Arizona bar?
If an ABS law firm wants to add an investor, somebody comes in and says, "Hey, I want to give you $150 million and I want 20% of the firm," whatever it is. If they are going to meet the threshold of being an authorized person, then the ABS law firm applies, and that individual, whether it's a company, a private equity fund, a venture capitalist, a marketing company, whoever it is, or an individual, that person files an authorized person application. They make all the disclosures of everything that's in the code. And assuming that they go through the background check, then they're approved as an authorized person.
Okay.
So there's a filing fee for everything, of course, but that's to help defray the cost of the background investigation, which takes a while. But that's how people are adding additional investors.
And that time frame, if you were to go through that, you had the documentation ready to, one on average, would you say would be that time frame right now?
That's going to be a that's going to be a couple months at least,
Okay.
several months, because again, there is one investigator. Arizona is a small state. Our Arizona Supreme Court does not have an unlimited budget. So we have one investigator, one staff director, and they have to do all of the background checks on everything. So it's taking a few months. But
Okay.
yes, some are still in the startup phase because think about it, you're starting a law firm. And people don't necessarily want to invest everything and sign leases and rent and employ people until they're licensed. So we, as an ABS committee, we certainly understand it usually takes several months to start ramping up until these firms even open their doors.
Okay, excellent. One of the big questions that had emerged even over 3 years ago when you and I were first talking, back then, I believe the Utah still had their sandbox at that time as well. But a lot of questions are also emerging now that Arizona's three years down the road, and we have all these learnings, and the world apparently hasn't, gone astray like some had predicted. What are some of the other states that you're aware of that are maybe going down this road with the ABS process, and who are they? Where are they at the process now? Where are we heading with other states potentially beyond Arizona?
We haven't seen a lot of other states jumping on board. Again, our profession, and I know we've talked about this before, but the profession is hesitant to embrace change quickly. So I know that there are many states watching still what Arizona and Utah are doing. Utah's sandbox is still going on, and they're still gathering data. The only state that I have heard recently that has published a report, actually in the last month, recommending ABS law firms is Texas. And Texas's Access to Justice Task Force is recommending this, but only for certain types of practice areas for people that are 200% serving clients who are 200% or below poverty line. And I'm going to get those numbers wrong, but you get the idea. They're looking to have ABSs done as a pilot project only to serve needy people, and not sure how that's going to go because Capital investment usually isn't just to do pro bono work.
Right. Exactly. And really no other states right now that are really afoot on this that we're aware of?
No, there are a lot of other states that have gone a different route in access to justice. And the other route is something that Arizona also did, which was adding certain categories of non-lawyers to provide some legal services. So legal practitioners, legal paraprofessionals, document preparers. We've seen several states adopt some pilot programs in that area.
Okay. All right, good. And then the final area I wanted to bring up was everybody talks about ABSs, right? And it's been the big buzzword but it wasn't the only change. As you mentioned before, there was a carve out of a different type of profession, but also the fact that Arizona literally changed their, model rule 7.2b, as you alluded to earlier, about paying referral fees to non-attorneys. And we just talked about that a moment ago in a couple scenarios. Are there any other states that you're aware of that are also considering those types of changes as well, or is it just Arizona?
Just Arizona, and even Utah has kind of backed off of that, and they're not changing their regulations on referral fees. I would say I'm aware of a lot of Arizona lawyers in traditional law firms that now are paying a percentage of fees to marketing companies, litigation funding companies, and lead generation companies. So that is something that we are seeing. Kind of a surprise that as many firms are doing it as we thought. It's a little bit of the Wild West, but lawyers still have an obligation to make sure their fee is reasonable. And actually, our Supreme Court clarified the rule and said, you know what, if an Arizona lawyer is paying a referral fee to just another lawyer, that doesn't even have to be in the fee agreement. Because if that other lawyer is not even working on the case, it's just a referral fee. That does not have to be disclosed in the fee agreement, because really, Dustin, what do clients care? How much is the total fee you're charging me? I don't care what you do with it once you earn it.
Right. Understood. And have you seen any upticks as well in complaints around that change in the Arizona rules any more than usual, or?
That's a great question. So far, I have not seen any bar charges on that.
Interesting. Okay, great. Good.
Yeah.
Well, we covered a lot of the questions that I've been hearing a lot of. Lynda, is there anything else that we might have left out that you think would be worth adding for other people to hear about?
I would just remind everybody this is not a get rich quick scheme. If you're interested in applying to be an Arizona ABS law firm, understand you're buying and running a law firm. Think about it seriously, because we on the ABS committee certainly are thinking about it seriously.
Absolutely. Well, Lynda, great information as always. A great follow up on our interview from 3 years ago. And if anybody wants to get in contact with you or help or assistance with this, what's the best way to reach you?
Email is probably the best way to reach me. And that's Lynda, spelled Lynda, at shelylaw.com. And that's SHELYLAW.com.
Or they can just go to your website as well, I presume, correct?
They can go to the website. Yes, shelylaw.com.
All right, very good. Well, Lynda, thank you so much. This was very informative, really helpful, and appreciate your time today. And thank you for everybody who's watched today. If you like this video or want to watch additional legal content from law leaders, please subscribe on YouTube, and thanks for watching.
Thanks.